Good morning. Welcome to the first meeting and first public hearing of the Special Select Committee of the Senate on the Evidence Offences Amendment Bill 2019. This hearing is broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I am Clarence Rambrat. I'm chairman of this select committee. I now invite my colleagues on the committee to introduce themselves, starting on my right.
Anthony Vera.
Donna Cox.
Good morning, Saddam Hussein, member.
And good morning, Nigel De Freitas, member.
Thank you very much. I should point out that Senator Thompson, IE, is an independent senator who has been given leave by the committee to participate in the deliberations and discussions of the committee as is provided in the standing order of the Senate. The committee is supported by the secretariat provided by the Parliament, Mr. Lucio, Mr. Greenwich, and we're also supported by the staff from the Attorney General's office and the Chief Parliamentary Counsel's office, and they are here to support the committee. The Honorable Attorney General is expected to participate also. He's indicated that he may be running late at this time. So we have before us today, and I thank you for accepting our invitation and also making your written submissions, the representatives from the Director of Public Prosecutions Office, the Trinidad and Tobago Forensic Science Center, and the National Forensic DNA Databank. And when the committee met in camera before coming here, we identified the stakeholders before us as very critical to the success of the work of this select committee, which has been appointed by the Senate to review the bill, to conduct the appropriate discussions with stakeholders, and to report back to the Senate by the end of November 2019, and we intend to do so. So I now want to invite the three stakeholders before us to make your opening submissions based on your written submissions and whatever else you wish to share with us. So we'd start with the Director of Public Prosecution, then follow with the Forensic Science Center, and then the DNA Data Bank. So thank you very much. DPP.
Beg your pardon. It's a signal honor. Well, let me start over. I would like to thank the committee for extending its kind invitation to my office. It's a signal honor to be here. These issues, as they pertain to the Evidence Amendment Bill, are very, very important issues, especially when viewed against the backdrop of a criminal justice system that has appeared and has in fact been moving rather sluggishly over the last few years. The Evidence Amendment Act, and in particular those sections of the Act which pertain to special measures, I welcome them, and I am on public record for at least 10 years now as an advocate for special measures, especially in the unwholesome climate of fear which tends to pervade, if not cloud, the ambience that sometimes exists in the courtroom. The Evidence Amendment Bill, as I see it, can go a long way towards obviating certain problems associated with identification procedures, and this can in turn result in the amelioration of the criminal justice system. It is not a magic bullet or a panacea that would automatically and ineluctably result in the system being improved, but I see it as presenting an opportunity for other ingredients in the cocktail of measures which the country has a duty to the citizens to create so as to deal with the problems or some of the problems which are currently besetting the criminal justice system. It is in this context and against that backdrop, I look forward to making a contribution before this committee, and I trust that we would engage in rather wholesome discussions. Thank you.
Thank you very much. Forensic Science Center.
Trinidad and Tobago Forensic Science Center core function is to process evidence gathered by the police officers of the Trinidad and Tobago Police Service and to report on these items of evidence. We prepare certificates of analysis that are used as part of the judicial system in assisting the DPP and the police officers in prosecuting these cases before the court. The officers who prepare these reports are also summoned to court on many occasions to testify as witnesses, as expert witnesses. As a result, the evidence bill dealing with witnesses, ID parades, and video conferencing is very relevant to us in how we present our case before the court, and is very relevant to the climate in which witnesses are asked to present evidence. And it is a great honor for us to be invited and to be here to contribute to this bill.
Thank you. DNA Databank.
Hi, good morning. I'm Justin Lewis, DNA Custodian Manager. I have alongside with me my Databank analyst, Tonya Marie James. We both compiled the comments that we're going to detail today. The Databank basically is a repository of DNA profiles from crime scenes and persons mentioned in the DNA Act. We compare profiles to find matches, contaminations, familial associations. We provide reports to the police on matches, of course, and to the Forensic Science Center. I'm going to say that we are not experts, in the ID parade policies and regulations. However, as scientists, we do see value in providing comments, and we'll get through them today. Thank you very much.
Thank you. I would now invite Member Vieira to lead the opening questions on behalf of the committee.
Thank you, Chair. Good morning, everyone, again. Director, first of all, congratulations for presenting us with a very helpful brief. Clearly, you went through the legislation with a fine-tooth comb, and your package is well received. Now, one critic has described the provisions on the anonymity orders as a perjurer's charter. What's your take on that?
I think at first blush, such a contention might appear to be somewhat seductive. But bearing in mind how the law of perjury works, I do not see this particular provision as precluding the law enforcement authorities from acting against a perjurer. So I do not think such a contention can easily bear any real critical scrutiny.
Thank you. Now, I noticed you also made comment about the photographs. A couple of other commentators have made reference to that bit. I'm wondering, there's something called choice overload, where psychologists talk about the dangers of having too many options to choose from. Do you think that the number of photographs being shown to a witness runs the risk of choice overload?
That might be so in a particular case, but I do not agree with that in this case, since the touchstone of any identifying procedure must necessarily turn and hinge on fairness. And it is only fair for the identifying witness to be asked to make identification from a number of photographs, as opposed to one photograph, two photographs, or three photographs. Having said that, on the other hand, it might be inefficient, being hypothetical and reasoning in extremis, for the identifying witness to have to choose from 500 photographs. The way how it is laid out in the Act, it is my office's view that this is perfectly permissible and fair.
Thank you. I just have one other question, and I'm sure other members would have. Are there any aspects to the legislation that you would have a concern about or that you find troubling?
Apart from what I would have reduced into writing in our submissions, I do not have any particular concerns outside of those.
Member Hussain?
Thank you very much, Chair. Good morning, Director. Director, I was reading your submissions that was submitted to the Secretary of the Committee. I noticed that there was a heading, Order of Priority of Identification Procedures, Rights and Representatives. Now, members of the public would not be aware or have an opportunity to have read these submissions. Can you just take us through with respect to, in particular, the order of priority as listed in the bill currently before us, whether or not that is adequate, or should there be any changes in terms of amendments? It's at page 2 of the submissions.
The opposite section of the bill is, the opposite section of the bill is section, or clause 12E1. And it reads, if I may be permitted, where an identification procedure is to be conducted, it shall, subject to the practicability or the availability or cooperation of the suspect, be conducted in the following order of priority. A, identification using video medium in accordance with section 12J. B, an identification parade in accordance with section 12K. C, identification in a public place with the consent of the suspect in accordance with section 12M. D, identification in a public place without the consent of the suspect in accordance with section 12N. Or E, identification by confrontation in accordance with section 12O. When we speak, or when the bill speaks about priority, it simply means that the procedure identified at A in the adumbrated list of 5 options would first be adopted, and if it's not practicable to adopt that first procedure, which is identification using video medium, then you go to the second one, which is an identification parade in accordance with section 12K. If neither of those are practicable, then you go to the third one, as opposed to giving the police and law enforcement the opportunity to just choose any of the 5. They have to start with A, and if A is not suitable, then go to B, then go to C, then go to D, then go to E. That is what is meant, and that is how I interpret the types of identification procedures in the context of an order of priority.
Director, particularly with respect to the order of the priority, Are you satisfied that the first method of identification during the course of the investigation should be by video, or should it be by identification parade as opposed to video? Because at that stage, let's just assume that the suspect is in the custody of the police.
Well, as we had outlined in our submissions, we were of the view that the first item in the order of priority should be the identification parade. Since if the first item in the order of priority is identification using the video medium, there are certain things that might be lost which may otherwise aid an identifying witness to make a positive identification. For instance, depending on how the video medium is used, it will wholly exclude the prospect of the witness asking the officer conducting the procedure to have the suspect or the persons in the identifying, in the video medium, to walk, to talk, to bend, to stretch, to do other things which may lend itself by way of confirmation of a positive identification. Whereas at the ID parade, it is well settled that a witness might properly ask the identification parade officer to have the suspect, and by extension, all the persons on the parade, say a particular word, make a particular motion, walk, raise their hands, etc., etc. The video medium, with the video medium, you would lose all of that. So it is my respectful view, and it's the position of this office, that the first in the order of priority should be the identification parade. Now I know that increasingly the police are having problems in this climate finding and getting persons to agree to go on an identification parade. Well, in those circumstances, if the identification parade were to be the first in the order of priority, then it may no longer be practicable in that case for the police to go the identification parade. So then they go to option number 2 in the order of priority, which would be the video medium. So you lose nothing.
Director, if we are to move identification parade up to the first option for identification, are you satisfied with how the order of priority with respect to the other options as listed currently in the bill?
Well, your question doesn't quite contemplate what would be the second item in the order of priority.
If we had to switch B and A.
Right.
Yeah.
Yes, I do.
Yeah.
I welcome the Honorable Attorney General and invite him to raise a few questions with the 3 stakeholders who are here before us today.
Good morning to everyone. Apologies, just juggling a few meetings, and good morning to the viewing public. I welcome the very distinguished representatives of the stakeholders who are here before us as key stakeholders in this exercise. DPP, you quite correctly put the reason for as the drafter of the bill and in electing the PACE methodology and in going for the priorities that we had seen in other parts of the Commonwealth, starting in England, we had selected the video as the first port of call. I certainly take on board the recommendation because it is without prejudice to the fact that it may no longer be practicable and therefore one can step to another step. I was just wondering your view in particular, if we're looking at 12E, whether in my mind as the drafter of the law, I had contemplated that video medium, even though 12J says moving images, I had not discounted the use of actually live video medium, in which case the advantages of directing the witness to stretch or to move, forgive me, the person in the parade to conduct certain things which could assist the identifying person in that point. I had really had in my mind the concept of live imagery also falling into that. Do you have any views in respect of that?
That may go some way in addressing the concern that I would have raised earlier, but I still see it as having the possibility of falling short of the benefits to be derived from an identification period.
Thank you, Sue.
In practical terms.
May I, having been the last person to enter the room, be so bold as to ask for some of your views and thoughts on this very strong concept of witness anonymity. As you know, this bill contemplates using witness anonymity and orders in very strict and certain circumstances. It's a rather unique feature for us, something which I think has been thought about for quite some time. As the person with responsibility for a large part of the operation of this arena, would you mind giving us a little bit of expansion of your views on the proposed witness anonymity orders that this law contemplates?
There was a time when a section or a clause or clauses like these, as they pertain to witness anonymity, would have attracted much concern on my part. But given the present climate and the prevailing winds, those concerns have to a large extent been defanged by the practical realities extant in Trinidad and Tobago today. So, in those circumstances and against that backdrop, I find that the clauses as they pertain to witness anonymity in this bill, I find them to be unexceptionable.
Thank you, sir.
Coming back to the order of priority, at the last hearing, the police had indicated, like you, they wanted a change in the order. So I'm just going to run the order that they had proposed and ask how that squares with you. They had suggested, first, B, an identification parade in accordance with Section 12K. Secondly, identification in a public place with the consent of the suspect, which is C. Then D, as 3, identification in a public place without the consent of the suspect. And then 4 would be identification using video medium. And then 5, which is E, identification by confrontation. Would that be an acceptable list in terms of priority for you?
I have no problem in principle with that suggestion.
Could I just have a rejoinder here? In my mind, again, as the drafter of the law, I'm tempted to include the fact that the video medium may be live. And I think that it's reasonable that many of the stakeholders have viewed this to be something which is filmed and then played to the witness. The mischief that we're trying to treat on the drafting side, I accept the B moving to A route, but just to put in mind that the mischief that we were trying to achieve was the reluctance of people to participate, because there was a chorus of concern that the bottle of rum or the scotch or the whatever it is that people use, the $200, it's quite hackneyed in terms of the incentives that people are used and the limitations, and also to the fact that people don't want to find themselves in these circumstances of participation. I do propose, subject to the committee's view, of course, to perhaps look at the modification of the video to make it clear that it does not include filmed historical records, but that it can also include live video medium, because in that circumstance, we thought that we would have a greater participation of people, because they would be in a remote event where a conductor could ask somebody remotely to do something or to do not. I do remind honorable members that when we're looking at 12E, it is subject specifically to practicability and availability or cooperation, and therefore that is a huge consequence. I was trying to find a mechanism of flexibility in the circumstances, if I could say it this way, again in a hackneyed way, to think outside the box. So I hope that that helps from a drafting perspective.
My concern is that we have a particular culture in Trinidad and Tobago. We have a particular way our courts interpret legislation and do things. So there's always a difficulty and sometimes even a disconnect between what the law says on paper and what obtains in practice. And I think what we're trying to achieve is to get that right balance that would work in practice. So for example, one of the concerns that has been expressed is about, for example, not being able to get hold of station diaries when you're at trial and you're calling for things like that. Are there any areas in this legislation that you can see gaps arising where we need to shore up, not just what's on paper, but in terms of, say, infrastructure, support systems, and so on?
Well, there are several areas of the legislation which I believe can be shored up so as to meet with the concerns that the honorable member has expressed. And I would have reduced most of those concerns into writing in my submissions. If I might get into one particular as it pertains to this issue of identification procedure, and something which I would have alluded to in my submissions, the whole area of identification procedure, when you look at the Act, it strangely leaves out the issue of verification. Now, if we're looking at an order of priority, it might be that verification should find itself at A. So if a criminal offense is perpetrated by someone well known to the victim, like my brother, if my brother, God forbid, were to wound me with a cutlass, the police, as a matter of duty, would still want to carry out an identification procedure using me as a witness so as to identify my brother. That is called verification, and it doesn't find itself in the Act, notwithstanding the fact that the Act speaks the identification procedure. And more particularly, when you look at the definition section of the Act, it speaks the identification procedure and it defines it thus. Identification procedure means a method or system of ascertaining or determining the identity of a suspect for the purposes of an investigation, and as specified in section 12E1A to E. In my respectful view, section 12E must necessarily include verification. This is a major omission in the Act.
DPP, I can say immediately off the bat, Mr. Chairman, as the drafter, that I sincerely thank you for that observation at 12E for the inclusion of verification. I also note with great appreciation the recommendation for incorporating certain aspects of the judge's rules into the text of the position. And I also welcome the observation that some of the penalties are far too low and that we should adjust them. They are very powerful recommendations. DPP, may I ask you, this is something that I have been knocking on the door of, and in the course of the debate I raised it. In the Anti-Terrorism Act I raised it. In a number of pieces of law I raised it, and I wish to thank you profusely for your recommendation or observations at J of your submission, which is to be found at page 5. This touches and concerns the adverse inference from silence. Our jurisdiction, forgive me for being a little bit long in the run-up to the wicket. I'm conscious that people are observing the proceedings and may not be on the point of law as quickly as we would be, and therefore I could be a little bit briefer if I was speaking only to lawyers. Our jurisdiction is often compared to other Commonwealth jurisdictions, in particular the United Kingdom and the United States, where convictions come with rapidity and trials are much briefer, and where defenses are viewed to be less complicated in terms of allegations of fabrication. And those are all driven from the application of the adverse inference to silence rule. I note at paragraph J of your submission that you have a suggestion for reform and the use of adverse inferences from silence, and you've very usefully quoted from Murphy on evidence and disclosure of defense, and you've also noted that the limited form of practice direction by the Chief Justice in our jurisdiction is already in place. Could I ask you, for the benefit of the public, on such a nuclear submission, a powerful submission to truly take the reform of our law forward, could I ask you, please, to give us a little amplification on paragraph J of your submission?
Certainly. A useful starting point might be the criminal procedure rules. The criminal procedure rules are designed to make trials more efficient, put simply, and there is this issue of the right to silence, which is a very, very touchy issue, especially if you were to hold discussions with those persons who are numbered among the criminal defense bar. Having opened in that way, adverse inferences from a person's exercise, or a person's silence, I should say, may go some way in making trials speedier, in expediting the criminal justice process. Because what you find happening is, and it also may go some way in ensuring that a verdict rendered by a jury of the accused pairs is a true verdict. One has to look at the right adverse inferences from silence in at least two ways. One, you look at adverse inferences from silence in the context of pre-charge operations by law enforcement, and you may also look at it in the context of directions a trial judge is required to give to a jury in the context of adverse inferences from silence. What you find happening from time to time in criminal trials, notwithstanding the stellar efforts of the Chief Justice by dint of his practice direction, is that persons are still proceeding to trial, hoping in some instances to patch, construct, and reconstruct their defenses depending on how the prosecution's case evolves. In other words, they may remain silent at the investigative stage. They may remain silent at the stage where the person is charged. And depending on how the prosecution's case goes, notwithstanding disclosure being made by the prosecution, then you find that some persons construct a defense. And I'm not laying this at the feet of the attorneys. But then you find, well, let me put it another way. There's the prospect that a defense might be advanced, which isn't a true defense. Now, if a particular act, reasoning hypothetically, would have occurred on X date, and the accused is alleged to have been the perpetrator of the crime, if his defense is an alibi, he doesn't have to wait until 2012 to indicate that his defense is alibi, because he already knows that. And the law has already gone some way in treating with that defense alibi. So, to some extent, the law has already made an incursion into the classic right of silence. And I'm saying that the time may have come, subject to the issue being treated with by way of discussions, further discussions with other august bodies, for us to consider this is not a plea for us to implement or to do away with the right to silence. This is merely an invitation for this committee to consider in all the circumstances whether or not the time has come for us to go further in terms of the right of silence, and whether or not in going further, or some persons might very well contend, whether in making a further incursion or sortie into the right of silence, whether we are doing an injustice to accused persons, or whether, on the other hand, by making that type of incursion, we are ensuring that the product delivered by the criminal justice system is a fair product, or a fairer product.
Director, I thank you for that, because you've given a nuanced position. You have indicated that you are not at all looking to interfere with the right to silence, but that in certain circumstances, adverse inferences may be drawn. Now, you made an interesting observation, and it is something that my own view is that what we're really talking about is not only about changes in legislation, but behavioral change in the way trials are conducted. When I look at the new criminal procedure rules and the case management procedures and the overriding objective, and I look at the Chief Justice's practice direction on defense statements, I think we have already gone a long way. It's not so much a matter about bringing in new laws as it is about implementing what we have effectively in the courtroom. Would you agree?
I do. That the criminal procedure rules would have gone some way, and to a large extent, the implementation of those rules and the enforcement of those rules, while it's a work in progress, there are certain lags that are occasioning some concern. Initially, when the criminal rules were first brought into effect, for some strange reason, this whole issue of the defense's case would have been left out. That is why the Chief Justice had to come back in the report charge, by way of the report charge, with the practice direction. And when you look at other jurisdictions, if you are talking about efficiency in the trial process, how do you say, well, the prosecution should disclose, the prosecution should let the other side know what the case is, but the other side, the defense bar, they are allowed to proceed in the process almost by way of ambush. And hence the reason why the legislation would have gone the way that it did in relation to alibi. Because what used to happen in bygone days was that at the trial itself, during the pendency of the trial, accused persons would, just before they went into the box, if at all, indicate that their defense is an alibi. Or the prosecutor might hear it for the first time when the accused person testified in the box. Now, in those circumstances, how could that process have been fair? Because when would the prosecuting authorities would have been able to find the time to check out the alibi when? And even if the judge were to adjourn to give the prosecuting authorities time to investigate the alibi, how could that make for an efficient trial?
Director, could I please invite, and again, thank you for being here. This is an issue which, albeit I've raised on umpteen occasions on the floor of the Parliament, it doesn't necessarily resonate unless it comes from the practitioner and the person with constitutional authority to speak to these matters, which obviously under Section 90 is you. Could I ask you to connect now to another very material and important submission in your written submissions, which is the substantive closing statement argument. This is at paragraph N of your statement. There's a recommendation and an observation which warms me that we look at section 15.2 of the Principal Law, the Evidence Act, and there's a recommendation that the prosecution be given an independent right to give a closing address, which is not necessarily tied to the defense. Could you, for the benefit of the listening public, indicate the rationale for that submission, which I will confess, not even as a member of this committee, but as the drafter of this law, I warmly accept?
From time immemorial, the prosecutor was tasked with the onus of proof. Onus simply means the obligation or the responsibility of proving. The prosecutor also has to meet a particular standard of proof. The standard in criminal matters, classically, is proof beyond reasonable doubt. There are some criminal matters where a different standard of proof becomes applicable. It usually finds itself embracing legislation which gives or which creates a reverse burden of proof on the accused. Now, the prosecution has the obligation of proving. So the prosecution bears that mantle. Now, classically, it was seen, and it is seen as in this way. The prosecutor's right to address the jury is like a right of reply. So if the defense doesn't address the jury, what the prosecutor replying to? The right of reply was seen in the context of a reply to the defense's closing arguments. So if there were no closing arguments by the defense, then the prosecutor didn't have a right to reply to anything. So the trial would then proceed without any address to the jury by the prosecutor or the defense. And the judge would then go on with his summation and so on. This submission is made in the context of the prosecutor having this obligation to prove. And even though the defense makes the tactical choice of not closing, because the prosecutor carries the burden of proof, and the standard must be proof beyond reasonable doubt or proof to the extent that you feel sure, you being the jurors, it is my respectful submission that notwithstanding the fact that the defense chooses not to close, the prosecutor should be still allowed to make closing submissions to the jury, consonant and complementary, consonant to and complementary with the prosecutor's obligation to prove.
And this will, of course, be an amplification of the manner in which we adjust the behavior in trials as opposed to fairness and procedure, because obviously one has the right to speak. So if there's a clear intention that the prosecution intends to address, then of course the opportunity for the defense would always be there, and therefore the balance would be struck. Yes?
I would like to, yes, but I would like to add a caveat to that. In this jurisdiction, unlike in some other Anglophone jurisdictions, the prosecution has the last word to the jury, ordinarily, where there are addresses being made to the jury. I do not want this submission to be construed in such a way that it is interpreted as though I'm saying that the prosecutor should no longer have the last word.
I understand it in the other way.
Because the way it reads, that is an interpretation open to you when you read it. But I'm saying that is not what I'm contending. Mm-hmm. I'm saying that bearing in mind that the defense would know if the law is adjusted or changed, amended, the defense would know that, listen, that tactical choice that we would ordinarily have made, it mightn't make sense to make that choice now. And there, it's open to them in those circumstances to address. And in certain circumstances, they may very well do that. So I'm not for a moment suggesting that the defense be allowed the last say, since they have no burden to discharge.
Thank you, DPP. Sorry, Mr. Chairman, one last very important point that I'd like the DPP's assistance on. And this is, again, in respect of another one of the anchors of this legislation. Again, as a drafter, I considered the need for Trinidad to have special procedures and CCTV evidence in use for vulnerable witnesses to be a core treatment for something that ails our society. That is, that there is a lack of witness evidence because of fear, intimidation, and other belief which causes witnesses to simply be put out of the system because they believe that they can't be protected. Section 12AA of the legislation, which is at page 41 and 42 of the legislation, treats with the concept of special measures evidenced by video link and witness anonymity orders. And specifically at 12AA, we treat with vulnerable witnesses and special measures. Now, the definition of vulnerable witness at subsection 3 is put into persons who are likely to be affected by reason of age, immaturity, physical disability, mental disorder, trauma suffered by witness, fear of intimidation of the witness, and the witness being virtual complainant in proceedings for sexual offenses. We have the concept of vulnerable witnesses under the suite of legislation that treat with children on a standalone position and also in the Family and Children Division law which we created. You have made a very, again, important observation at paragraph K of your submission, on the last page of your submission, where you make a submission that subsection 3 of 12AA should contain a specific provision for witnesses in gang and terrorism prosecutions to be deemed vulnerable witnesses. I welcome this suggestion. As the drafter, I had really sought in a framework kind of perspective to include that under paragraph D, which is fear of intimidation of the witness or. But I do generally believe that in treating with Trinidad and Tobago's current situation, that there would be an express benefit to singling out the concept of witnesses in gang matters and terrorism matters, because we have had matters of this type and have matters of this type in our jurisdiction come to the fore. Could you lend us a little assistance in disaggregating the special mention of vulnerable witnesses in gang and terrorism matters from the framework of fear of intimidation of the witness in subparagraph D? And I'll also ask you to consider whether we ought to now be having a discussion about special procedures and special advocates in a voir dire kind of context where an application is made and we have to now manage the access to the vulnerable witness. So let me put that one, if you'd permit me to flesh it out. Right now, in wrestling with another piece of law, which I'm in conjunction with many stakeholders on, including the Office of the DPP, the fairness of excluding witnesses from being met by the accuser is the subject. So there is an accuser who is a defendant in proceedings. There's a witness who is giving evidence. The witness is a vulnerable witness, let's say. The witness is somebody who statute says ought not to be identified in certain circumstances. Other jurisdictions have a process referred to as a special procedure where a special advocate represents, it's done in the UK for terrorism matters, etc. They'll represent the interest of the accused, but that attorney is a vetted attorney from a panel of vetted attorneys who will approach the case on behalf of the witness, of the defendant, to now test in a special forum akin to a voir dire, meaning a side discussion, as to whether the judge ought to allow the evidence or not. In looking at this general issue of vulnerable witnesses, applications which may be made, and then in this special cohort of terrorism and gang matters, do you think the time has come for us to adopt that special procedure? Panel of vetted attorneys who will interview carefully the accused and the accused attorney, approach a judge, have the judge consider the propriety of granting the order, and then allow the process to continue. Could you assist me?
Honorable AG, when you look at section 12AA, subsection 3D, there's a very little word that attracts huge concern. It's the definite article and the word the. Persons who are up to no good in the criminal world may intimidate or do acts pertaining to persons other than the witness. So the fear of intimidation of the witness would not catch that at all. It's not the fear of intimidation of a witness. You're using the definite article, THE. So the intimidation of relatives, friends, etc., persons within the inner circle of the witness, this would not catch that. Terrorism and offenses under the Anti-Gang Act, they are offenses which, in my respectful view, should attract a very high degree of moral blameworthiness. And consonantly, prosecutions under the Anti-Terrorism Act and the Anti-Gang Act, to my mind, make for particularly dangerous situations for witnesses, not just civilian witnesses, but witnesses. All of us are aware as to the threats to law enforcement and to other persons in the society which ordinary prosecutions present. Bearing that in mind, it is easy to understand the multiplier effect on one's fear in circumstances where you are dealing with matters under the Anti-Gang Act and the Anti-Terrorism Act. With respect to the second issue raised by your good self, the idea of vetted attorneys dealing with these supposedly vulnerable witnesses, as you know, is a novel one in this jurisdiction, but it is something which operates in other jurisdictions. But I would respectfully crave your indulgence and perhaps try to focus your mind on the resource problem that is faced by Trinidad and Tobago. At this current time, there are several trials, several matters awaiting trials in the courts of Trinidad and Tobago, especially in the case of murder, where one of the big bugbears is unavailability of counsel, especially by way of the legal aid clinic. And as you know, this has given rise to discussions pertaining to different system whereby you create an equivalent to the DPP's office on the defense's side. Now,
The office is rented, the staff is advertised, and hopefully during the course of November and December, the Public Defenders Division will be
public
briefed.
defenders, indeed.
Yes.
Now, the question that, just like if you're starting a family, at the present time you have no children, you might very well wish to construct a home in contemplation of the arrival of children sometime in the future. And as a good lawmaker, one would expect that you would have the vision in terms of the development of the society, in terms of the maturing of the society. You do not want to have to make amendments every year. But having said that, the question also arises as to whether or not that voir dire exercise, given our resources at this time, whether or not that voir dire exercise cannot be properly conducted by trial judges. I think at the moment, our trial judges are fully empowered, capable, and highly competent to deal with the voir dire situation involving supposedly vulnerable witnesses.
Important clarification. Wow. Let me put that simple word on the record. So the mischief in my mind was protecting the accused who is facing a witness anonymity order or a special procedure, CCTV utilization, etc., and how I would allow the accused the right to interrogate the process of the grant of that order in the pseudo voir dire setting or voir dire setting. Is it that you're suggesting that a judge who's not involved in the matter can supervise the interest of the accused before the judge who's hearing the voir dire?
I do not see why that is necessary with respect, because as trials go now,
The same trial judge.
the same trial judge, we have to trust our judges.
Question. So would you be comfortable? So the risk in other jurisdictions as painted is that if we allow the accused via his attorney alone to know the identity of the witness in full circumstances and interact in that voir dire setting where the application is made, that could be a risk that goes back to prejudice the very vulnerable witness we were looking at. So the other jurisdictions have grown up with this practice of using another defense counsel, quote unquote, a counsel to represent the rights of the defense in that setting. How would you suggest that we manage that process of who the correct person to represent the accused will be, where there are allegations that the representative of the accused, to borrow Commissioner Griffith's expression, criminal lawyers, as opposed to attorneys at law who practice in criminal law, may be involved in the situation?
First of all, I am loath to borrow Commissioner Griffith's expression. Having said that, there is legislation in this jurisdiction as we speak, and the common law allows certain applications to be made without the accused being present, his attorney being present, and the applications are made. And the process has never attracted the allegation of unfairness. One of the issues that readily comes to mind is the whole issue of public interest immunity.
Yeah.
For those matters, we do not get a separate attorney, and in some instances, the attorney is excluded, not the attorney, the accused is excluded from the process, excluded, quote unquote. Even if you look at this act, this bill before us, in relation to screens and so on, the accused may not be allowed to see the witness testifying, but the screens mustn't prevent the accused attorney from seeing the witness. So by way of symmetry, what's the difference?
Thank you so much, TPP. And I guess I could amplify that by saying that the practice that is engaged in children matters, where these are now run-of-the-mill, par-for-the-course sort of thing, are also symmetrical.
Yes.
Thank you so much, DPP. Appreciate it.
Director, I just have one more question, because you touched about the resource problem, and I'm sure we're going to have questions of the other panelists on that point. But I'm asking this question more for the record and for the viewing public, because we know the answer. We live in a time when there's a lot of cynicism, if not a jaundiced view about prosecutors and the police. And so, unlike some jurisdictions where district attorneys and prosecutors can actually be political, and they can use it as a stepping stone to political careers, in our jurisdiction, the office is seen as a minister of justice. It's constitutionally protected. And you actually have a code for prosecutors, which makes it quite clear you're not a rubber stamp for anyone, police, politician, or otherwise. Could you speak to us a little bit in terms of giving assurances of impartiality, fairness, and so as prosecutor?
I suspect that is not the intention of the honorable member, but to my mind, identifying a need to give reassurances obliquely suggests that there is some strong contention that the prosecutors are not ministers of justice, or they do not act as such.
Let me hasten to show you, not at all. It's just that in the context of this legislation, which people may be looking at it and saying, well, you know, this is a charter for the heavy hand of the law to come down and be oppressive. I want to say that in the office, it is actually going to be doing the administration of the prosecutions. There's a check and balance there as well.
The Office of the Director of Public Prosecutions, I can assure you, is an impartial office. I'm also of the view that the empirical evidence would show that if at all that office wields a sword, the sword is sharpened on both sides. As for guidelines and further assurances, the raison d'etre for the promulgation of the Code for Prosecutors was so as to provide the public with the opportunity of demystifying prosecutorial decisions and the operations of the Office of Director of Public Prosecutions. Hence, the reason why I spared no effort in being at the forefront, thanks to the assistance of the British government and the Canadian authorities, of publishing the Code for Prosecutors. And I will tell you that we are guided by that code, Prosecutions in Trinidad and Tobago. The litmus test is the full code test, and the full code test is a test that has been warmly and trenchantly embraced throughout the Commonwealth.
Mr. Chair, can I ask, as we're on the topic of the forensics division, Mr. Sanka, may I ask you, sir, to lend, as we're on the concept of vulnerable witnesses, part of your submission involves applying the definition of vulnerable witnesses to forensic experts. I can also say that there is a live discussion for persons involved in interception of communication, which we're treating with in a different piece of law at this moment right now, as we are very far advanced in a proposed amendment to that law, and we're looking at the concept of vulnerability. So at page 4 of your submission, you address the category of persons who ought to be included in the broad definition of vulnerability. And you also very usefully proceed with your support for the CCTV and video linking evidence. In fact, we have had cases as recently as last Friday where the complication of getting evidence from foreign jurisdictions comes about, and persons who retire and migrate elsewhere fall into this mix. Would you mind, for the benefit of the public and for the benefit of the committee, assisting us with your views as to vulnerable witnesses and video testimony and anonymity orders as put out in your submission?
The Forensic Science Center generates various types of certificates of analysis based on the evidence that we process. Some may be pathologist reports, there are ballistic reports, which are involved in analysis of exhibits from murder cases, homicides. There are dangerous acts, offenses under the Dangerous Drug Act with large quantities of drugs. And as a result of that, we are witnesses like any other witness. We provide expert opinions. We present a report before the court. Depending on the type of offense under the anti-gang legislation, we are sometimes witnesses in those matters as well, because many of the members of the gangs are perpetrators of homicides. They are involved in firearm-related offenses. They are related in serious drug cases. And as a result of that, we are seeing that we are linked, intricately to those types of offenses and presentation of evidence in court. As a result of that, we may be in a position, as the climate is now, that we are vulnerable to certain types of implications in those matters. And as a result, from my own experience, we would appreciate that the vulnerable witness be extended to us. We appreciate also the fact that the video link will help us testify in matters of a very serious nature. We have pathologists who have retired and have migrated for various reasons. We have scientific officers who there are still cases outstanding that are maybe required to attend court. We had at one time American fire and ballistic experts who worked over a period of 3 years with exhibits from the Forensic Science Center and are now called upon to testify in court. We have experts from England as well who examined and tested our exhibits, prepared certificates of analysis, and may be required to attend. For the sake of cost, for the sake of convenience, we are asking that the video link procedure be available to us to give that type of, for them to give that type of evidence. So that the smooth flowing of the court will take place. We are also very grateful if the vulnerable witness at every stage we are allowed to participate in contributing to the applications made to the court if we fall within that purview.
Thank you very much, Mr. Sanka, and before you, the DPP. We deliberately allowed an extended time for the Director of Public Prosecutions because a lot of what is submitted by the DPP is also addressed in your submissions from the Forensic Science Center and the Databank. I want now Mr. Sanka to give you an opportunity, followed by Mr. Lewis, to take us through your submissions. Now we have the written submissions and we've read it, and I want you to just take us through and highlight, particularly for the benefit of the viewing and listening public. You highlight the key areas of your submission, and thereafter, Mr. Lewis, I'll come to you and ask you to do the same thing, and then I would come back to the Director of Public Prosecutions to ask you to address those aspects of your written submission. I've counted at least 10 recommendations you've made. I'll ask you to address those which you have not already addressed. And before I ask you to do that, I'll ask you something in relation to witness anonymity. So before I invite you, Mr. Sanka, to continue, I want to invite Member Hussain to make a submission.
Thank you very much, Chair. Chair, is a question to Mr. Sanka. Mr. Sanka, the aim of this particular piece of legislation is to really get faster trials and get the system working in a much more efficient manner. One of the complaints that we hear very often is a resource issue at your establishment. Can you give the committee an idea of the average time it will take for the production of a ballistic report from the date of submission of the item or even certificates of analysis?
Let me say at the outset, there are a number of stakeholders that make representations to the Forensic Science Center for ballistic reports. The Police Complaint Authority, summons from police officers through the Magistrates Court, the High Court, are sent to us. Police officers who require management of their cases in an expedient manner will make written requests. The Forensic Science Center manages these requests and place in priority those requests. We have a backlog of ballistic cases, but we prioritize according to the needs from the police officers, from the police commissioner, from the various stakeholders. And we recognize that some cases will require fast-tracking, as they say, and we fast-track those cases because they are probably before the court, probably because you have two witnesses in custody and you would like a ballistic report to negative or positive, the case moving forward. We look at police shootings as well, where it involves a number of firearms that will be taken out of service if the police officers' firearms are seized and kept at the Forensic Science Center over a long period of time. So there are a number of factors that we give weight to in order to expedite those priority cases. On a daily basis, requests are made. On a daily basis, decisions are made. And we try to assist all stakeholders, especially the police officers and the court, in moving forward with those cases. The ballistic, having prioritized the case that comes before the scientific officer who specializes in ballistics, the officer now has before him an exhibit that has to be opened. There may be a number of cartridge cases, bullets. There may be 2 firearms, 10 firearms. So the time for processing a case from the point of opening the exhibit to closing and reporting will vary according to the amount of exhibits and in the number of microscopy items required analysis. Microscopy, by that I mean matching a bullet from a crime scene or from a body to a test fire or in a particular firearm. So it may take 4 hours, it may take days. Sometimes the bullet is not as detailed as other bullets, and the scientific officer will be required to spend more time on the case. So it may take hours as well as days.
Okay, thank you. Member Vieira?
Director Sanka, obviously the Forensic Science Center is a critical institution to this undertaking of dealing with crime and enforcement. But we've been hearing of late, there's going to be an increase in judges, there's going to be an increase in courts, we are streamlining procedures, so one can anticipate increased demands on the center. You already have said that there's a backlog and you haven't to prioritize according to need. My question is, can you cope with the anticipated demands, and also what measures are in place to keep pace with those increased demands on the center?
Could I just interrupt, because it's more so a resource constraint that is provided to the Honorable Director of Forensics. What I can say, just to prove the MOU between India and Trinidad for the increase in forensics, similar one with China, and the location of the forensics division at the Mount Hope location is in fact set to go, save for clearing the land which is currently under litigation. I have personally also attended to Jamaica, where we have dealt with some of the expansion of forensic facilities. So from a governmental perspective, there's an aggressive simultaneous expansion, like we are trying in every other area, to make sure that we operationalize the system. So I can see at least, and this is always so odd when we have committees where primary government members sit on the committee with first-hand knowledge. But being one of the persons involved in this equation, I can say there are at least 3 MOUs, land already identified, structure ready to go. As soon as we clear the injunction at the Mount Hope site, which the minister and chairman has done, we expect to have a rapidity of expansion going on right now. So there is good news ahead. Is that enough to manage the pace at present? No, obviously. But having recognized what is required, there's an aggressive anxiety to get it done.
Well, I think that helps answer your question, but I still am interested in knowing, in light of what the AG has said, what would you identify as your priority list of needs?
Well, in further support of what the Honorable AG has said, is that the new Forensic Science Center is projected to be 6 times the size of the original Forensic Science Center, at least 6 times, or approximately 6,000 square feet of land, or square feet of floor space. In addition to that, the ballistics section, we have had discussions, and I personally has undertaken a project where I will train, together with the firearm unit, at least 12 police officers or other suggested persons with Bachelor of Science degrees or bachelor's degrees and master's degree to train in the specific area of forensic ballistics. This is a highly specialized area. Having knowledge of firearms is not enough. You need to actually be specialized in the area of microscopy, matching the striations in the bullet to the particular firearm, test bullets. And we intend to train those ballistic officers, be it police officers or members of the Army or other persons, in those areas to help us reduce the backlog. So with the priority of cases that we have already in train, we will get those persons trained to assist with the backlog in a short-term basis and in the long term, because the police officers, they are, as we envisage, they are salaried, they are paid, so that will assist us in cost, and we will do the training free of charge, together in harmony with the police service and their use of their facilities. The biology section, which also has a backlog, the public service has supplied our cadre of officers, so there are no vacant positions at the Forensic Science Center. We have had recently 4 forensic biologists who are now scientific officer ones trained, are waiting to start casework in that area as well. So with a strategic move, we are hoping that we will point our guns, so to speak, at the target areas of ballistics and biology. We are grateful for the Honorable AG to inform us of the new Forensic Science Center, but we are not awaiting for that. We are taking immediate action in those 2 key areas where there's a backlog of cases. And with the scientists at the Forensic Science Center and strategic moves and approval by the Permanent Secretary, Ministry of National Security, we are looking to attack that backlog head-on and be very proactive and useful to the courts in providing these cases in an expeditious manner.
Just to give one position, again, to both members that have asked these questions, we have approached the issue of law, every single law that we have brought, with the following formula in mind: plant and machinery, people, processes, and law. That is the only way we've been able to open courts, increase facilities, and increase rapidity. It's the first time that 4-pronged approach has been applied with a consistent measure. So I'm very grateful that the members have asked the question and can hear it live from the proverbial horse's mouth.
Thank you very much. Mr. Sanka, could you proceed with your, as I asked, that you identify the key aspects of your written submissions. The members have had it, we've read it, and particularly in the interest of the public, that you go through the submission for us.
A number of the submissions, the Honorable DPP has indeed addressed some of those issues in the questions addressed to him, specifically in the first 40 pages, but I will comply. Section 12E, at page 8 of the Evidence Amendment Bill, that deals with identification procedures. It is suggested that the first description be taken from the words of the station diary. This record in the station diary must be made by a police officer who is in part of the investigation team as soon as practicable, after interviewing the witness for the first time. And this is important because if that is not done due to a failure to do so, it leaves room for allegations of prompting witnesses by police officers. And we are saying that that note in the station diary should be done as promptly as possible. With respect to section 12D, page 13, we are saying that the identification officer should not be a police officer or an inspector from the same station. We are saying that the inspector may come from another station. We are also concerned that whether the inspector is from the same batch of police investigators. They may have a personal link, and we are concerned about that, but at least the inspector should be from another police station, not from where the investigating officer works, because this will leave room for bias against the accused. Under Section 12E, page 14, we are identification by confrontation, as the Honorable DPP has alluded to, is that that is the last resort, identification by confrontation. And we are in full agreement with that. With respect to Section 12F, page 15, a note should be made of what measures were put in place to have the suspect be provided with legal representation. It is suggested that a legal aid officer be contacted and the accused be allowed to communicate with that person in person or by phone to get advice on the identification process, and a note of this made in the station diary. We are also saying in most cases before the court, an accused person would deny he was given the opportunity to contact a friend or family or a legal representative. It is important that provision be made to enforce the right of the accused. Page 33, point to page 33 on the evidence bill. Section R, 12R2. This section suggests that the interviewee or his representative can request a copy of the entry in the register of interviews in relation to his interview. The question is, would the police officer inform that person of that entry? And we are saying that the police officer shall inform the interviewee, that he is entitled to this entry. It exists and should be pointed to it in the actual station diary. Right? There must be provisions for the interviewing officer to inform him of his right to have a copy and put a note to this effect in the station diary. And if he has requested the same, a note will be made of this in the station diary, and the person receiving sign the station diary on receiving same, so that he cannot come and deny that he was informed of it. The section mentions a representative or his representative. The Constitution of Trinidad and Tobago states that a person arrested is entitled to have an attorney at law, friend or relative, present. As such, any of these could be present. There have always been allegations by the accused that he was never informed of his rights when he is brought before a court, charged with an offense. Provision should be made to have this accused contact a legal advisor by phone, such as a legal aid lawyer or a duty counsel, or be given names of attorneys at law to contact in order to receive advice of his rights. We are also saying that the suspect interview should also request that legal officers or the attorney at law contact a friend or relative to visit him. Under Section 12R2, page 33, we are saying this section suggests that the interviewer or his representative can request a copy of the entry. We already alluded to that before. And if we look at page 34, section 12S2C, this caution should, after being given to the interviewee, be explained to him in simple language. Where the accused has a legal advisor, he would be advised what this means, that he has the right to silence, and he need not give an interview, and it is voluntary to do so. The Honorable DPP has gone into that, and we will not say anything further on that. Section 12X1, page 38, where a suspect or person charged makes an oral admission and a note of this is made in the station diary. If the admission is made before he is legally advised by a legal representative or in the absence of a legal representative, the interviewing officer or the officer in charge of the investigation should, as soon as possible thereafter, make all efforts, as mentioned above, to communicate with a legal representative and have him present at the station. And there and then, in the presence of the legal representative, the note should be read to the suspect of his oral admission. And at the end of the reading, the note should be given he should be given the opportunity to state whether the note is true and if he made it of his own free will and if he signed to same. A note of what transpired should then be made in the station diary and the accused and his legal advisor be asked to sign. Should they refuse to sign, then another note should be made to this effect. At page 41, section 12AA, as I had indicated, we, at the forensic experts at the Trinidad and Tobago Forensic Science Center, we view ourselves as depending on the circumstances of the case and the matter before the court, we view ourselves to be considered as vulnerable experts. And in those circumstances, we should be able to make that application or make that communication to the respective court through the different media, and for the court to consider whether that is indeed so by all the factors the court have alluded to in the Evidence Act. We also would like to be considered to present evidence in video link, using the video link in special circumstances because of the nature of the crime and the case and the persons involved. We would like to be encapsulated within that and have that opportunity to do so.
Mr. Sanka, could you provide a little more detail on that? In the context of the circumstances in which you wish to be involved, that you are not already involved, and you had raised before some of the practical issues with people not being present in the jurisdiction, but beyond that, in what circumstances do you see yourself being involved?
Well, in terms of the actual presentation of the nature of the case, the witness may be very crucial in determination of the case. If it is a homicide, if it is involving some heavy firearms, related matters, dangerous drugs, and if it is that we were previously threatened, for example, by a phone call, which has happened before, by phone call,
right, just clarifying, so you would, the witnesses from the Forensic Science Center in certain circumstances should be considered for witness anonymity protection?
I feel so, yes, that is my strong belief.
Right, okay, thank you.
And I say so not as director, but previously I operated as a scientific officer. I function as a scientific officer. My specialty is forensic ballistics. And I have testified in a number of matters before the court, in homicide cases, firearm-related matters. So I'm speaking from first-hand experience.
Which gives me an opportunity to you and to the DPP, because I had planned to ask the DPP this question. When the committee met with the representatives from the Trinidad and Tobago Police Service, I just want to draw your attention to, in the bill, 12AG2. And the issue raised, 12AG2 reads, a party to criminal proceedings may, in relation to a witness, make an application to the court for a witness anonymity order. And in those discussions with the TTPS, the question was asked, where does the criminal proceedings start? And from a practical point of view, I myself and I know others have tried to determine, particularly in the context of the amount of disclosure that is required in criminal proceedings and the timing of the disclosure having to be made as early as possible so that the accused party may meet their defense. So I want to ask you, in reference to 12AG2, where does the criminal proceedings begin? At what point? And at what point is this witness anonymity order sought? And how does that work in relation to previous disclosures that have been made in preparation for the trial?
Forensic Science Center looks at the matter of the initiation of proceedings, we receive exhibits from police officers. The exhibits are, the police officers give instructions to process the exhibits, and these instructions are complied with at the Forensic Science Center. At this stage, we do not know if there will be impending proceedings or not. We do what our core competence, we process the exhibits, we prepare a report, and we send it out. At a later stage, we may be communicated with and be told that we have to appear in court, which is the normal course of events for some cases. Not all the cases we process will be in the court's jurisdiction. As a result, after preparation of the cases, if we are summoned to court, we go to court. So from the forensic point of view, our matter starts with the receipt of the exhibit.
DPP, do you have a view?
A criminal trial usually begins upon the accused being arraigned. In the magistrate's court, one might say upon the defendant being, the charge being read and he's called upon to plead. But there's a criminal trial. Criminal proceedings would begin, in my respectful view, from the time that the accused is charged and brought before the court, and the proceedings commence with the reading of the charge. I think that's when criminal proceedings begin.
So, how do you see that working in relation to the witness anonymity order?
In relation to witness anonymity orders, it is my respectful submission that the witness anonymity order would properly be made at any time after criminal proceedings would have commenced, but before the witness is due to give evidence.
Okay, thank you. Mr. Sanka, you could continue.
We are asking in support of the video link where we can give evidence over video or via video conference. And this is now very applicable to us for one, our safety, two, the availability of some of the experts who have retired and have migrated, for former experts who came from other jurisdictions to work at the Forensic Science Center from England and America. This is a perfect medium for which to bring the trial to them rather than they have to come to Trinidad to testify in our courts. It reduces cost and time and allows for speedy preparation. And we would like to be included as part of this act for video link preference and privilege. In terms of a support person, we are also asking that in certain circumstances, and it depends on the offense, that a support person be provided for us as expert witnesses, because if we are deemed vulnerable, then the support person will be one of those tools or persons to assist us to provide security and make us comfortable in the circumstances. So we are in support of Section 12A, page 44, the provision of support persons to the forensic scientist or the expert in the relevant matter. We are also in full support of a risk assessment of the endangerment be conducted, because it will all be part of the same procedure to be deemed as vulnerable or not, whether we are deemed a vulnerable witness or not. So that risk assessment, we are in full support of that as well. And of course, it is all linked closed circuit television to present expert evidence as part of the tool used to present evidence before the court. We would like to be represented in that. We have that privilege to access that opportunity. As it exists now, we are summoned to court and we give testimony before the court and in the presence of the accused. In the future, we are looking at the future where things may be a little different.
Thank you very much. Mr. Lewis?
Okay. Good morning again. So, we reviewed the amendment bill and provided the following comments. Under Division 2, Identification Procedures, 12B, number 1, prior to the conduct of an ID procedure, this may imply that the suspect is known and available to participate in the procedure. Fine. And they say that they may want to use photographs. So we are suggesting that these photographs, some regulations should be applied because the contents of the photograph may lend prejudice to the witness and may form some bias against the suspect. That's one. Under 12F, we're suggesting a clause should be added to basically let the suspect know the reason why he's being identified in this procedure. I think it's his right to know why he's being in an ID procedure. All right. Under Division 3, which is under interviews and oral admissions, we looked at 12Q, and we're suggesting that a clause again should be added saying, before the commencement of an interview proceeding, a suspect and or his representative shall be given sufficient information about the nature of the offense and why they are suspected of committing it in order to allow for the effective exercise of the rights of the defense. Under 12S, we're suggesting to add another clause that says, whereby the interviewing officer under this section shall also, in the event that a removable recording medium is used in the recording of the interview, ensure that the new and previously unused recording medium is unwrapped or opened, loaded in the recording device, and set to record in the view and presence of the suspect and or his representative. Under 12S, I want to add another clause basically speaking about where there's a change in the recording media or a break in the recording process or even the failure of the recording equipment. There should be some discussions regarding that. And finally, under 12Q, 12S, or 12X, we're suggesting to add a clause to provide for the interviewing and the recording of interviews of juveniles, incapable persons, and vulnerable persons, and even non-English speaking interviewees or suspects. And those are our brief recommendations to the evidence amendment bill.
Thank you very much. DPP, I want to come back to you as I indicated and ask you to take us through your recommendations, except for those you've already given us some detail on. I recognize you have at least 10 recommendations, and I would ask that you just take us through those recommendations, and that would give the opportunity to the members of the committee who may have questions on those recommendations to raise those with you.
Thank you very much. The first recommendation pertains to the issue of first description under the Act, and in particular, Section 12A2C. And we would have recommended that the proposed clause 12A2C be widened so as to include how many times the identifying witness would have seen the person who committed the offense before, and whether there was anything impeding the view of the witness, as is required by the case of Lavonde and the Queen versus the state. In relation to the use of photographs, and this respectfully is a particularly poignant matter, it is my respectful recommendation that photographs ought not to be used by the law enforcing authorities while a suspect is in custody. I should put that more properly. Photographs of the suspect, and indeed photographs, should not be used while a suspect is in custody. The photograph may be used so as to assist the police to arrest a suspect. But if the police would already have arrested a suspect, the use of photographs before an identification parade can and will make for some contamination of the integrity of the identification procedure. Recommendation number 3. We are of the view that an identification parade should be held when it would serve a useful purpose, and accordingly, Section 12C2 should be amended or reworded so that the word necessary to do so is replaced with the word useful. In addition to which, when you look at clause 12C, subclause 2, you'd realize that the words necessary to do so appear, and yet still, in the very act, if you look at section 12C, Roman numeral 4, the act itself uses the word useful. So for consistency, internal consistency, I respectfully recommend that the word useful should be used in both places. It is also recommended that the identification procedure well, let me put it another way. It is also recommended that the abrogation of the need for an identification procedure, if the suspect admits presence and gives a similar account, it is respectfully submitted that that flies in the face of the law and common sense. And I would tell you why. An accused person or a suspect may in certain circumstances admit presence and give a similar account as the witness does. But the court later on may find that that admission is inadmissible for different reasons. If the court makes that type of ruling, that would infect the case to the extent that there would have been no identifying procedure in the case. So what you would have is the court making that ruling, and then if that is the only evidence in the case, or that's the main evidence in the case, the prosecution is fatally compromised. I also recommend that the committee look closely at section 12 Clause 12E1, which again speaks to the identification procedures and the order of priority. But in this instance, I would take you further into clause 12F, where the legislation purports to give rights to the accused persons that they ought not properly to have, or that they do not have. For instance, in relation to the rights which the suspect should be advised of in the proposed section 12 or clause 12F, namely the right of being advised of legal aid. This presumably refers to the statutory right to duty counsel under the Legal Aid Act at section 4.1. But that is restricted to certain offenders and certain offenses. It's not a blanket approach. It is also unclear as to why the suspect needs to be advised at that stage of his right to be presumed innocent, or that he be advised of his right against self-incrimination, when we already have the judge's rules and the police are already mandated to caution suspects according to the judge's rules. So one would not wish to create a situation where the courts have to settle any conflicts, overlaps, or interceptions between the judge's rules and the proposed bill legislation. Further, the recommendation in the Act that the suspect be given 9 hours notice for his representative to attend an identification procedure. It is a bit opaque to me as to how the drafters would have arrived at 9 hours. Why not 6? Why not 12? Why not 3? Why 9? But more particularly, one must bear in mind that from the time someone is arrested, time begins to run, and I'm putting this liberally, against the police. So by giving the suspect this 9-hour period, that might be too long. And in our recommendations, we are submitting that the suspect be given a reasonable opportunity in the discretion of the identification officer, and this would be tested by the court and in court, so as to have the suspect's representative attend. And failing that, once the identification officer is of the view that a reasonable opportunity would have been given and spurned, a justice of the peace, an impartial person, may then be appointed to protect the accused or the suspect's interests. It is to be noted also that this bill places considerable reliance on justices of the peace, and they are in short supply. This reliance can be lessened by the adoption of the formula in Rule 6 of Appendix B of the Judge's Rules on the taking of statements, which permits a responsible member of the community to safeguard the investigative procedure. We have reached a stage where, inexorably, the only body of persons we are minded to task with this particular responsibility are justices of the peace. But there are other persons and categories of persons in the society, in my respectful view, who can discharge this obligation outside of that category of justices of the peace. In other jurisdictions, for instance, in the jurisdiction of St. Vincent and the Grenadines, a lot of the times the authentication and the witnessing of statements is done by responsible members of the community. I was Director of Public Prosecutions in St. Vincent for a couple of years, and it was the norm for school teachers, principals, head teachers, bank managers, etc., to play the role of the authenticating or witnessing independent person. With respect to the recommendation as it pertains to the video medium, which looks at clause 12J of the bill, it is noteworthy that there is no independent representative or representative of the suspect in attendance at the video medium identification. And that can be perceived and characterized as unfair to the accused or suspect. In relation to clause 12K, clause 12K, subsection, subrule 5, it reads in the bill, where the suspect is representative or a justice of the peace objects under subsection 4, the identification officer shall, where practicable, take steps to remove the grounds for the objection, or where it is not practicable to take steps to remove the grounds for the objection, the suspect is representative or the justice of the peace shall be told why his objection cannot be met, and this shall be recorded in the approved form. The legislation, perhaps unwittingly, seems to contemplate the ineluctable compliance of the police officer conducting the identification procedure to meet and remedy the objection made by the suspect's representative. Put another way, it is my respectful submission that the identification officer shall, where practicable, and if he agrees with the objection, take steps to remove the grounds for the objection. As it reads, once there's an objection, it appears as though he must take steps. That is unfair to the identification officer and is unfair to the prosecution. And again, it might result in common sense being our blind spot. In relation to interviews and oral admissions, if we look at clause 12Q, I'm sorry, section 12W. Clause 12W, subclause 4, which reads, where an interviewee or his representative is present at the breaking of a seal under subsection 2, either of them shall be invited to reseal the master copy and sign the seal. I'm respectfully submitting that the law enforcement authorities would have to be particularly careful with this. If this piece of evidence is incriminating evidence or contains incriminating evidence against the suspect, it is difficult to contemplate a good reason for putting the piece of evidence into the hands of the suspect. I've already touched on the matter of adverse inferences from silence and also special measures and CCTV footage, but there is a point in relation to the special measures that I would also like to to raise. It is my respectful submission, and special measures appear at clause 12AG of the bill. That would be page 48. And in particular, the witness anonymity orders. When you read this legislation, a huge concern attending upon that reading of the legislation is the fact that the legislation doesn't appear to contemplate that an accused person may wish to make an application for a witness anonymity order for his witness. In matters involving gangs and so on, you would find that an accused person may wish to call a witness on his behalf who himself might be fearful of giving evidence in favor of the accused person, whatever the interest of the state or the prosecution might be. So it wholly ignores the prospect that the accused might wish to make an application for a witness anonymity order. And to that extent, the legislation is skewed asymmetrically so as to make unwittingly for an unfair outcome in the context of the rights of accused persons. In relation to forms and procedure, and in particular reference to clause 12AJ, it is my respectful recommendation that having regard to the impact the material covered by that section could have on the criminal justice system, the Director of Public Prosecutions should also be consulted by the Minister together with the Commissioner of Police. And in relation to clause 12AL, it is my respectful submission that this clause creates a statutory discretion to exclude prosecution evidence, but it is my respectful recommendation that the common law position be codified to the effect that a trial judge is given the power to exclude evidence that is more prejudicial than probative. What one should try to avoid is any incipient conflicts between the common law and the legislation unless the express intention of the legislation is to depart from the common law. And that completes my task of taking you through my submissions and recommendations.
Thank you very much, DPP. I know my colleague, Senator Hussain, Member Hussain, has a question. And after that, I would ask each of you to make your closing submissions if you have any.
Thank you very much, Chair. DPP, thank you very much for your fulsome submissions, both in writing and before the committee. During the course of the debate on this bill, some points were raised on whether or not we should introduce criminal procedural appeals during the trial. For example, where trial judges make decisions on procedural matters, whether or not we should introduce that in our jurisdiction. Can you give me your views on criminal procedural appeals?
It is my respectful submission that the advent of criminal procedural appeals would be counterintuitive, counterproductive, and would fly in the face of any notion or prospect of the expeditious hearing of matters. What you find happening is criminal procedural appeals would tend to, or could tend to defeat the purpose of case management. defeat the purpose of the criminal procedure rules, cause unnecessary interruptions in the trial, cause unnecessary interruptions in the case management process. Procedural issues, in my respectful view, should be dealt with at the trial or at the earliest, in some cases, at the case management hearings. If those issues go the wrong way, or if there's a feeling that they should be appealed or an appeal should be brought in relation to the rulings on those issues, that could be taken up after. But it has been my experience, one of the most inglorious instances would have been the situation as it pertains to the Piaco cases. There were several interlocutory, to use the civil term, applications made during the pendency of those proceedings. And some of those applications would have found themselves going right up the chain to the Privy Council. It resulted in almost scandalous delays in the carriage of those matters. And those matters would have taken a much longer time than they should have. And in other jurisdictions, those types of interlocutory applications may not have been allowed, perhaps may not have been allowed in a jurisdiction like the UK. They would have been taken up after. So they allow for constant interruptions of the process, and they would be counterproductive given what we appear to be trying to do.
Thank you. Mr. Sanka. Member Thompson.
Mr. Gaspar, DPP, I must tell you thanks very much for the very comprehensive document that you supplied to us. I'm sure you see this legislation as a new way of thinking of the government to have prosecution, people who have committed crimes brought to justice by providing as much assistance, as possible, and especially to the prosecution has sometimes very constrained. Would you therefore agree that with this new thinking of the government should come along not just a look at this legislation, but other legislation that may be relevant in terms of how we treat with potential witnesses? Do you see any need for us to look at legislation such as the Police Complaints Authority Act, where you may have a witness who will come under the jurisdiction of description of being vulnerable, and yet when you look at how the person may be treated, in that the person may be threatened to, that you can have a conviction, a fine of $50,000 and to imprisonment for 5 years if they don't cooperate with the Police Complaints Authority. Can't you see a situation where a police officer, because of perhaps his history or because of the nature of the offense, may in fact provide such fear or give such fear to a witness that the person may not want to come forward, and therefore the legislation could be amended and perhaps include without reasonable excuse or something like that to assist in those circumstances, because eventually it's going to come to you in your department to deal with. Another thing, would you agree that perhaps the Justice Protection Act should also be looked at? Because all of that is involved when you have to provide protection for a witness. We've had so many witnesses who have been killed because they walked out of protective custody. And you have some jurisdictions which actually provide that someone who is in protective custody as happened recently with the lady who went to the birthday party or whatever, that person should be accompanied by someone. So that provision could in fact be one that could come into our legislation. When you look on page 50 of the bill, and you see the provision, the clause E, and it speaks about whether the fear of giving live testimony by an intimidated witness is well-grounded and that the risk of intimidation justified. Do you think that clause could be improved by, instead of using the word well-grounded, that it is supported by credible evidence, as occurs in some jurisdictions? You would be aware of the controversy between the European Court of Human Rights and the Supreme Court because of the whole question of anonymity of witnesses and, you know, the amount of confusion that arose, and the head of the Supreme Court had her say, and, you know, a number of things happened. I think now there is some kind of truce, but it aroused a number of ill feeling, a bit of ill feeling between the Supreme Court of England and the European Court of Human Rights. So perhaps we ought to look to see how, at the end of the day, we could learn from the experience, because any erosion of common law rights creates a lot of uneasiness. And although this legislation is well-founded because of a real problem in society, that perhaps we ought to look to see, you know, how other jurisdictions, a bit more, have tried to improve on the legislation, on their way of dealing with the, you know, the old situation that we've grown up with, and all the common law rights that are being eroded, and there's some concern in the community about that. And I'm saying this particularly because we don't always catch the Attorney General in, you know, in these forums. So as he's here listening, and he spoke about that he's the draftsman, you know, so I take this opportunity to speak to him by speaking to you, sir. Thank you.
I'm right here, and always available, honorable member, especially to you. But DPP is as good a candidate as anyone else.
Thank you. Mr. Sanka and Mr. Lewis, any closing comments?
Questions of the
DPP?
Honorable member, you would appreciate that you somewhat conflated several questions with some of your observations, which made it a bit difficult to identify clearly which questions you wanted me to answer.
Oh.
What I got clearly is that you were using me as a conduit to make a convenient echo in the air of the Attorney General. And I have no problem with that. But to the extent that I understand, and I would have been able to grasp exactly what you wanted me to deal with. In relation to the PCA, it cannot be gainsaid that the legislation creating the PCA and governing the PCA may be in need of amendment. In relation to the Justice Protection Act, which is the act creating the Justice Protection Agency, which is the agency which is mandated to carry out tasks pertaining to the protection of state witnesses. If a state witness goes to a party, you do not have to legislate that somebody should go with her. While you cannot prevent somebody from leaving protective custody to go anywhere, because being in protective custody as a witness is entirely voluntary. You could advise, but there are other ways, some covert, that can be employed to monitor the witness who, despite better advice, chooses to leave the sanctuary of protective custody. It's not something that sometimes we try to legislate practices that really should be undergone by way of the initiative being taken by the responsible authority and the responsible authority being charged and tasked with managing the affairs properly. Not everything we might be able to legislate for. Yes? In relation to section 12 or clause 12AG, if you'd bear me one moment, please. Page 50. You raise the issue of whether the fear, the sub-clause, whether the fear of giving live testimony by an intimidated witness is well grounded and the risk of intimidation justifies it. Admittedly, the term well grounded is not a term that you would usually find in legislation. It sounds very prosaic and is not, it also sounds somewhat amorphous. But to suggest that it be replaced, and I know it was only a suggestion, you're illustrating how it perhaps might be changed by the terms by credible evidence. Sometimes a reason may be justifiable, notwithstanding the fact that there is no credible evidence of it. Sometimes what you have is credible intelligence of it. Sometimes what you have is credible information of it, but no credible evidence of it. So in respect to the concern expressed that this legislation might, chip away at certain human rights and so on, we have to be mindful of the society in which we live, our polity, and anything that I would have said here today should not be construed as though, or to the effect that I am saying, there should be no further discussion on the matter. And you would also have used a term that the government is trying to do X, Y, and Z by dint of this legislation. I prefer to look at it in the context of what the country is trying to do, since there is also contributions from independent persons and opposition personnel.
Thank you very much, DPP. Member Cox.
I just wanted to refer to D, the last paragraph, with regards to Rule 6 of Appendix B of the Judge's Rules on the taking of statements. And you spoke about your experience in St. Vincent and the Grenadines, where it speaks about permitting a responsible member of the community to take statements to safeguard the investigative procedure. I just wanted to find out if, should these responsible people, type of responsible people, be itemized? Yes. But you think they should be itemized? Because for me, who I might think are responsible, somebody else may not feel that that person is a responsible enough person. So I was just asking your opinion, and if you think that these should be itemized.
And remember, the problem with itemizing is that you create an exhaustive category. So anybody falling outside that category, even though they may be a very responsible member of the community, they will not be able to make a contribution. What you can do is itemize some persons or some categories of persons. So you'd use the words including. So the category isn't closed.
Thank you.
Thank you very much. Mr. Sanka, closing submission.
Thank you, Mr. Chairman. The Forensic Science Center, under Section 14D of the Original Evidence Act, states that in any criminal proceeding or inquest, any record kept by a government expert relates to anything admitted to him for examination. Analysis or report shall be prima facie evidence. And the government expert at Section 19 includes the pathologist, senior pathologist, government chemist, armorer, forensic document examiner, forensic biologist, scientific examiner. So we are in the original act, and it is very appreciative that in the amendment that we are considered in terms of managing the forensic expert, in terms of the other aspects of the process in court, for example, in video linking, in the anonymity, because these are real issues that the experts have concerns with over the years and the nature of the cases that we are involved in before the court. So we are very appreciative of being part of this process where the bill is being amended. At the bill stage, the Evidence Act is being amended, and we at the Forensic Science Center are very, very grateful to be here.
Thank you, Mr. Lewis.
Yes, I want to piggyback on what Mr. Sankar said. We are grateful as well to be here for our contribution to be heard. I must add that we as custodian scientists are also witnesses in court as well to give evidence, so we should fall under the vulnerable persons if that would be considered in the future. That's all I have to add. Thank you.
Thank you very much. I want to thank the three stakeholders who have appeared before us, and you've spent your time going through your written submissions and taking the questions from the committee. I'm sure as the committee does its work, we may have further questions, and if you have anything that you would like to share with us that you have not shared already, you're free to make further written submissions. I want to thank the committee members, the representatives from the AG's office, our secretariat from the Parliament, and most importantly, viewers and listeners who would see this broadcast, listen to it now, and those who would listen to it and watch it later. I know the Parliament channel has a massive viewership, and a lot of people, a lot of members of the public are interested in what you described in your opening DPP as the cocktail that is being created to deal with the criminal elements in this country. And I like how you closed, that we have our own issues in this country to deal with, and sometimes it requires unprecedented action in the form of legislation that is properly passed by people like the members of this committee today. Thank you very much. Thank you, Honorable Attorney General, for coming. I know you had scheduling issues this morning, but we always appreciate your input and support. Thank you very much.